report is accepted at the hotline alleging that a vulnerable adult is the victim of financial exploitation. A report is taken, and within 24 hours, sometimes sooner depending on the situation, but within 24 hours an investigation will commence, and an investigator will try to make face-to-face contact.
We have 14 investigators that go out and investigate abuse, neglect, exploitation, and also self-neglect. We also have 5 case managers that do continuous case management for some of the clients that may need additional assistance.
Now, sometimes in a financial exploitation allegation, there may be neglect also involved that the investigator finds out due to lack of funds to buy medicine or the utilities, what have you. There may be abuse due to intimidation or threats or even physical violence in order to access the funds of the victim.
So they go out within either 24 hours or within 3 hours, depending on the severity. And they're trying to see a couple of things. One, is this person able to make their own choices, which in the state of Florida we call capacity. Do they have the capacity to make their own choices? Sometimes they do have capacity and they understand exactly what happened, but due to fear of retaliation from the caregiver or from whoever, they don't want any law enforcement involvement. They just want us to make sure it stops. And that is primarily our job, to keep them from being re-victimized. While we're there, a lot of times we find out it's the person on their bank account. You know, if they have capacity, we have to inform them. If somebody else is on your account, regardless whether they have money coming in, they can still take money going out. So we educate them about not putting anyone else on their bank account. If they have children, do their children know what's going on? Say the person maybe lacks capacity. We think they lack capacity, they can't make their own choices. We speak to the primary care physician to see, are they complying with their medications? Have they seen anything?
Now, once the investigator determines that their financial exploitation has occurred, or neglect or exploitation for that matter, they will make the appropriate referral and share the information with the local law enforcement and the state attorney's office for them to determine whether they need to conduct a criminal investigation.
So once we get that report and we look at it and say, okay, does it fall within the exploitation or the possibility of an exploitation, we'll send a detective, and a detective will be assigned from our unit, and we'll go knock on the door.
It's always helpful to collaborate with the Adult Protective Services, because there's always some things that they can do a lot easier than we can. Typically, any financial records that we require, we have to go and get a subpoena for, and that's a 3-day process to get it signed, and then however long the financial institution takes to get back to us, which could range anywhere from 24 hours to months, depending on how many records we're trying to get.
We're able to get bank records for our cases, and in doing so, we're able to give it to law enforcement to prevent them from having to get a subpoena, and that makes the case move along a lot faster.
It's not what we know, it's what we can prove. So it's important to gather records and work with other agencies that may be involved, whether it be DCF, Victim Advocate, or the State Attorney's Office, for a successful prosecution in the end. There's the Florida State Statute 415 is an enabling statute. It tells us about exploitation, it defines it for us. So we have to look at that and say, oh, first of all, does it fall within those realms? And then there's a charging statute, which is in the 800 numbers. So we look at both those and say, okay, can we take this? We use a decision tree. You know, certain items have to be met, such as the infirmaries of aging. Was there a capacity to consent?
Law enforcement should have an understanding of the specific needs and of a senior, because they vary so greatly from a younger person. Their fears are much different, and they're very valid because they are on fixed income. Their fear of financial abuse or being left alone, those are real important. And even the era, you know, you have to understand where these people are coming from, how they want to be addressed initially. You have to gain that trust of the senior, and having knowledge of the senior mindset is really important in order to do that. If a senior has a dementia that really complicates a case, but law enforcement should not necessarily shy away from that, and training can really help with that understanding.
The person that's exploiting the person may not let them talk with you alone. They may not let them be alone in a room with you because they're afraid of what they might say, what may actually come out. So it's important as much as possible to be able to interview that victim alone, because they may be willing to say some things when they're alone with you that they may not be willing to say if the other person's in the room.
you're going to find out that like some of these cases, the witnesses don't want to give you statements. They don't want to be involved even when they're not family members. They just don't want to get involved in these types of cases. So we're having difficulty overcoming some of these issues that present during the investigation.
Sometimes a different investigative technique, if you're unable to get the exploited person to talk to you alone, is to bring the Adult Protective Services investigator with you. If they've already established a relationship with the person being exploited, sometimes they'll feel a little more comfortable with saying things and talking with you if that person that they've already gotten the relationship with is in the room.
Because these are lengthy, in-depth cases and they require a lot of work up front. You know, because sometimes you can prove through the record when the suspect in a particular case may say, yes, they gave me the authority to do this, or, oh, I didn't do that, and then we come up with all this evidence of, 100 checks where we do have evidence. We have the uttering of forged instruments, we have the ATM withdrawals, or we have the manipulation of funds such as IRAs, etc. We just had a caretaker who was a relative and spent a lot of time manipulating records with the power of attorney. So we had to overcome a number of things. First of all, a piece of paper that gives them the authority to move records, him or her the authority to move records, and a victim who's saying these things didn't happen properly. And now we have to show all the financial records to match up with what they are confirming or what they are not confirming, and putting those things all together for a period of, a 2 or 3 year span. Sometimes we get cases that come in where a family member say, we believe our family member's been exploited. And what happens is we go and we talk to the victim in these particular cases, and they'll say, no, this is what occurred. Like in particular, we may have a case that comes in and they say, we have 2 prior reports, whether it be from DCF or the sheriff's office. They've already went and knocked on this person's door. Now, for example, let's say an elderly male who has a young wife who moves in. They get married and she's taking money. When the report comes in, because it's suspicious, because we do get suspicious activity reports through DCF, we go and talk to these people, where the victim will say, I've consented to this, I'm okay, and literally we've had them tell us to get out of their house. They don't want to talk to us, we're good. And we say, okay, we do our part, we document it, okay? And then 2 or 3 years later, we get the call from the family member that says his IRA is depleted, the credit cards are up, and some crazy amount of money they would never spend, and now they have no money at 70 or 75 years old, and they want something done about this. It's not what we know with these people, with the intent of what their intent is when they come into these relationships. It's what we can prove on these things.
If you have an uncooperative victim, if you have an uncooperative witness, because people are related and they don't want to get somebody in trouble, it's difficult to put the criminal intent behind what's going on. You have to be able to prove that there was some type of criminal intent going on.
We have to show there was an inability to consent. We have to have somebody who can testify to that, like a doctor who can come into court and testify and have a professional. They can say, yes, at the point in time or over a period of time when these events were occurring, this person was incapacitated, whether it be through Alzheimer's or whatever. They were incapacitated and lacked the ability to consent. We have to have the ability to a doctor to testify those things, to say, okay, now we can apply the exploitation statute. If not, there's still ways to pursue these, but it would have to go a different route. And we can't always do that, because sometimes, like we mentioned before, it's not everything what the family knows or thinks, but what we can prove based upon witness testimony, victim testimony, and records that are provided to us.
When it comes to exploitation of the elderly, time sensitive becomes more of a problem. Whether it be that the age of the victim or the actual health, and that's mental or physical health of the victim. You just never know where they're going to be the next day, the next week, or the next month, and whether they're going to be able to speak for themselves.